there, infested dead person with bugs on them in your jail that you pay tax dollars for. The jail is falling apart. The jail is under federal investigation for all of the things that occur at that jail that the feds are not pleased with. Unsafe conditions, inmates not receiving adequate medical care, employees having legal problems. So they charge Mr. Huey and Mr. Minder with possessing a shank. You will learn that there are cells that are left open. And that is not a safe place to be when a cell is left open and you're just trying to lay your head down and sleep. There are scenarios where you want the cell to be locked. So we're going to ask some difficult conversation questions when that time comes. So those are those particular counts. And Mr. Huey maintains his innocence with respect to those particular counts. Mr. Minder is not here today on trial. Mr. Huey is. Now, let's circle back real quickly to the count one RICO. So they have basically, the government has said, hey, look, you know, Mr. Huey and the rest of these 27 individuals were all part of this particular gang, YSL, and that they had this objective of power and reputation, territory, and all of that. And they put Mr. Huey in this indictment. Over at 102, March 12, 2020. If he don't take it back, he going.
What's popping, everybody? What's the deal? Support, what's the deal? DeMarcus, what's the deal? Jeremiah, what up, though? Oh, you already know I'm getting hot in the motherfucker. I'm watching my niggas stand on business right now. Trying to see what was going on with this YSL trial. Thanks for everybody who's coming through.
Guy, you heard Mr. Steele talk about these already, so I won't go back through them and belabor the point, but that is one of the messages there. And what are we talking about here? Well, to be very quick to the point, Chandler Durham, a music producer, make beats, help artists put their music together, brings them music, so they can lay their lyrics over them. You know, this is a person who had his car stolen outside Bishop Street, one of the studios over there in Atlanta. And I guess the word got out that there was a possibility that Mr. Huey may have known some of these guys or had the streets talk. This is Atlanta, Georgia. And it's a small community in Atlanta, Georgia. We're in a big city, but it's still small in certain ways. So the streets talk. So Mr. Huey was asked, hey, if you know something, you know these guys, or you can help us get that stuff back, just tell them to give us our stuff back. That's not a crime. That's not RICO. So you're going to learn that Mr. Huey was able to knock on the streets, knock on the doors of the streets, and help try to get this man his stuff back. He wasn't able to get all his stuff back. He wasn't. But he was able to get some of the stuff back, and he was able to secure it. And Mr. Durham was aware of it. And Mr. Durham had no issues with Mr. Huey at all. And of course, Mr. Williams had no issues with Mr. Huey. And Mr. Huey was able to help try to secure that. And you're going to hear evidence that it was secured safely for Mr. Durham as Mr. Durham was in LA. until he got back. Some of those items, not all. So this is the one where September 1, 2021, a recorded video call with Mr. Mender. Now, Mr. Mender, you may hear, as part of that Holloman case that we just talked about, you may hear a recorded jail call between Mender and some other person, some other female on the phone, and then some other male comes onto the phone, and they may tell you that other male was Holloman. I don't know. We'll figure it all out when we get to that point. But Mr. Mender is a friend of Mr. Huey. He's a friend of Mr. Williams. Mr. Mender was in jail, right? So Mr. Mender does a video call with Mr. Huey. Mr. Huey, being the friends that he is with Mr. Williams and trying to get work and be part of that label as an employee, and they grew up together. So he wants to be able to take care of his family, Mr. Huey. But on this particular day, this is not a crime. What's happening here? On this day, Mr. Mender is on a video call with Mr. Huey, and Mr. Huey had already had some communication maybe with Mr. Williams, and they're at a jewelry store. And you'll learn that just pointing to Mr. Huey to take care of Mender's request, how is that RICO? How is that RICO? How in the world is that RICO? That's not a crime. It's not a crime. But somehow they decided to put it in this indictment for your consideration as an overt act. September 4th, 2021, overt act 140. Mr. Huey had just been released from jail on the Holloman case because it had been dismissed at a probable cause hearing for a finding of no probable cause. So Mr. Huey was let go on that Holloman case. It was dismissed. So he walks out of the jail. He and Mr. Williams are cool. They're friends. They grew up together in the South. So he's traveled with Mr. Williams before on his private jet. What's the big deal? That's awesome.
That shit was a private jet.
So Mr. Huey, he says from lockdown, we beat that case. We beat it. It was dismissed. Now it's back in this indictment. So Huey said, hey, lockdown, we about to go to a concert. To Philly. He had a show. They went that evening and they came back. How's that RICO? How's that RICO?
The judge got a tiny ass bald head.
This goes back, count overt act 150. That's again dealing with the Chandler.
I'm with this nigga though. How is that the RICO? How is that RICO?
Durham. And like Mr. Still said, they want to give you that particular text or that particular communication, but the one afterwards, I don't even know if he really did it. That's what they didn't put in this particular indictment. So they're cherry picking. Then here we go, overt act 123. Terroristic threats. This is an uncharged event on a text message that they got from Mr. Huey's phone.
Good looking, my dog.
Justice Woodard is his lady. They have 2 children together. Mr. Huey has never been charged with a domestic violence offense.
I like his style.
He's never been issued a TPO. This was a text message between a couple talking, how they talk. And how in the world is this a RICO conspiracy overt act to enhance the reputation, the power, and the territory of an alleged gang? A text message between you and your lady talking? Maybe they were upset about something.
Exactly.
Who knows?
Exactly.
But they want you to believe that this was part of a RICO conspiracy.
Well, nobody's taking conspiracy like this.
And the evidence, ladies and gentlemen, you will learn that the government hasn't specifically talked to Justice Woodard specifically about a terroristic threat
I believe him.
of if you put the police on me, you're gonna die.
I believe you, man.
To this point, to this day. So we'll get in the case and we'll see what happens. But that's the overt act that they want to sell you on. As being part of a RICO. So those are the overt acts that are uncharged.
Overt acts.
So it's not a crime, but it is a crime.
They reaching.
So we'll deal with it. So we're here, guys. We're here. We are at the conclusion of this presentation. I have said it, and I'll say it again.
She needs to be listening.
When we get through hearing all of the state's witnesses and government's witnesses as it relates to all of these guys that are on this trial, including my client, Mr. Huey,
Judge about to drop a mixtape.
We're going to come back to you. We're going to stand firm, look you all in the eye yet again, and we are going to say to you humbly and respectfully that on these nuclear charges, count 1, counts 3 through 7, and counts 14 through 23, and counts 44 through 46.
Damn.
Mr. Marquavius Huey is not guilty. Not guilty.
Not guilty.
Not guilty.
That nigga ain't guilty, man. He's not.
So continue to take notes as you choose. Continue to listen intently. And collectively, you will make a decision. And that decision will be not guilty for Mr. Marquavius Huey on these charges. Thank you. And you are.
Hi, you're welcome, Mr. Matthews. Okay. Ladies and gentlemen, it is almost 6 o'clock, and I think it might be a stopping point for us today. What do you think? Okay, all right. Okay, so let's wind things down for today then, for you all. Okay, first, when you're back in your headquarters, same thing. You're going to probably know this script by the time that we spend with each other. Leave your notepads in the basket. Take a juror sticker for coming here tomorrow morning.
Hey, whoa. Hey, you can tell the judge ready to go.
Remember, all the ad nauseam admonitions I've given you, they still apply, and I know you all are adhering to them. So, please, just as a reminder, don't talk about the case. Even now that we've heard some witnesses, I'm sorry, we haven't heard witnesses. Now that we've heard opening statement, remember, opening statements are not evidence, okay? But we will go ahead and hear witnesses tomorrow. So it will be, I know that it might be very tempting once we start to kind of sit back in there and go, what do you think about such and such? Now, what did I tell you? Can you do that? Yeah. No, you cannot. So please be mindful of that. Don't recap the testimony as it starts going or coming to you starting tomorrow, okay? And don't critique or otherwise, talk about opening statements, because that would also be a violation at this point in time. I'll give you instructions on how you're supposed to, consider and deliberate this case at a certain time, but now's not that time. So right now, just remember the court's admonitions. I know it's also very tempting to listen to the case or on social media, as well as in the news. Remember, you can only consider what is brought before you in the four walls of this courtroom. Anything anybody else may speculate as to, say about this case or whatever is not for your consideration. You can only consider what's been presented to you lawfully in this courtroom. So again, don't listen to any of the news media accounts or go to any blogs or do anything that would be inconsistent with the court's ad nauseam admonitions, okay? Don't go by and visiting the scenes or anything that may have been talked about in court today. And as long as you all do that, then we certainly will be able to continue to give all sides fair trial, just trial, lawful trial. All right. So tomorrow, you're probably asking, what time are you going to come here? The question of the day, right? So, ladies and gentlemen, if I can have you here for 9:30 tomorrow morning for an anticipated 10 o'clock start time. And then we'll go ahead and call our first witness and witnesses. We should take a break sometime. So you can make plans for your holiday season, and for those of you that
these niggas ain't making no
celebrate or need to do other things, okay? But I will at least tell you kind of a couple weeks in advance when those weeks are coming. But I can tell you that we will take a bit of a break to allow everyone to have to get ready for the holiday season and otherwise prepare. So I'll talk with you more about that specifically on Thursday, okay? Or maybe even into the beginning of next week. All right, ladies and gentlemen, what ministerial questions do you have of me, if any?
Then can we go to the crib, bro?
Excellent.
Ain't nobody got
Okay, if you do, now's the time to ask me. Are your headquarters in there sufficient? Yes. No more stale popcorn today? Sorry about that. We'll get on the vendor that anyways, now. But ladies and gentlemen, I mentioned you earlier, you're welcome to bring any food, snacks for you all as a group. You're welcome to bring any. I see you all. Some of you have drinks and other comfort items. The only thing that I do not permit is two things. You can't have alcohol, that's by statute, and I don't permit gum, at least while you're here in open court. But you can have candy and any other thing that might help you focus and bear attention to this important matter. But as long as you pick up after yourself, you will not offend the court at all. Bring yourself a jacket. You can always something. You can take it off, take it on. As you can see, the courtroom here tends to be a little cold at times, but that's to kind of keep everybody comfortable, since we have a fair number of people in the courtroom.
Just making jokes and
shit, man. Ladies and gentlemen, unless you have anything else of me, Sergeant Ingram was going to go ahead and get you all straight for tomorrow, and Ladies and gentlemen, again, thank you for your patience and the patience that you'll continue to give this particular trial and the trial of this matter. So unless you have anything else, ladies and gentlemen, I'll go ahead and recess you for the evening. Leave your notepads in the basket, and we'll see you tomorrow morning for 9:30, okay? All right, all rise.
Damn, man, I got here too late today, man. We will be back. Free my nigga Thug. My nigga Thug done gained weight in that bitch. That nigga big as hell. Pause. My nigga Thug done gained about 50 pounds in that bitch. That nigga Gunner somewhere making a track right now.
All right, jury has left us. Please be seated.
That's crazy. That nigga Gunner out here making a track.
Okay.
So,
councils, tomorrow morning, I'd like us to be here for, and out here in the courtroom by 9:30. So I'd like you to be here seated with everyone here at 9:30, okay? So that we can go through.
I don't know if I can be here at about 9:30, but
hopefully you all have agreed upon, or not charged with the
if I find
limiting instruction, I should say.
The clips I want to look at,
if
I'll be back in about an hour or so for real. If I want to see some key points.
So I'm going to say this just so everybody's kind of clear. I would like to see a proposed instruction that I can offer to the jury.
Okay,
so that's what my goal is, or my task for you all to do is for you to come up with a proposal. And if you could email it to me, then I can go ahead, and all parties, then I can go ahead and edit it should it require editing. All right, that's the first thing. Any questions about that? Or any further clarifications about the court's instruction in that respect?
If we have dueling proposed orders, is it okay that we just submit them?
Yes,
okay.
Absolutely.
The prosecutor, hey, remember this, the prosecutor always
that's for the instruction. Okay,
the prosecutor always on bullshit.
The next issue. The next issue is Detective Belknap is going to testify first, and there's a very large PowerPoint that's been submitted. I assume that he's going to refer to. It's marked as stage 1.
I see why the judge trying to go home.
Is it a demonstrative aid, madam? It's not going to be admitted, right? So.
Your Honor, it's a demonstrative aid that we believe would assist him in explaining his testimony to the jury.
Okay. All right. So it'll be marked as an exhibit. Okay. All right. Okay. Specifically, are there objections or concerns? I understand you all just got that at this point in time. If so, please tell me.
Freaky ass, bald head ass niggas.
Your Honor.
Sir.
On March 21, 2023, Mr. Williams filed motion limiting number 13. Your Honorable Court granted that orally, reduced that to writing on November 17, 2023. I cite Swanson, SWANSON versus State, Your Honorable Court. That's at 366 Georgia Appeal 584 Division 2, 2000.
What was that? 366 Georgia Appeals. What was the other?
584.
584 Swanson.
Yep, Division 2, 2023. Your Honorable Court's order reference Swanson that an expert cannot discuss the law. Expert cannot testify as to opinion on the ultimate legal conclusion. Is not helpful to the trier of fact for the witness to express their opinions using legal terms or offer legal conclusions. The court must remain vigilant against the admission of legal conclusions, and an expert witness may not substitute for the court in charging the jury. On critical law, that's what you granted as well. Under Swanson, this was already argued. and ordered, and then as I look at what the state handed us,
I'll
which
be
I
back
believe
tomorrow,
is number
man.
one, if it's
No.
not, I'd like someone to correct me, but
It's stage one, sir.
thank you. And on the page that I have,
Assalamu
stapled
alaikum.
together, on the back of the first page, it has a triangle that you specifically excluded in your order, that you would not allow the supposed expert, it's not helpful to the jury, to talk about a person, then the gang, and then the crime, and the enumerated offenses, and employed by, associated with, or participates in gang activity. The next slide, or any piece of paper, is entitled Criminal Street Gang Defined. That is the law. That is exactly what Your Honor, Court and Swanson says cannot be done by an expert. The jury doesn't get from the expert, supposed expert. The next on the back of that page is Criminal Street Gang Elements.
Right here, Stan.
That comes from the
Standing
law.
on business, man.
That should not be coming from a witness. The next one is Criminal Street Gang Identifiers, which is a different issue, but I do have an objection, but not the same objection. That is not the law. That would go to factual allegations. Then it goes back to the law, Your Honor.
There are several slides in there that reference criminal street gang elements. So I assume that you're objecting to those. There are several of those
Yes.
interspersed throughout the presentation.
Exactly. And
Okay.
I don't have a page number, but yes.
Yes, it's not numbered, but but let me let the state respond to that to begin with. So, Madam.
Thank you, Judge. Your Honor, first, Swanson is quite distinguishable. In Swanson, what happened is that the expert witness was asked by the prosecutor whether or not something is required in order to convict someone of a DUI. And the expert answered no, which is an issue that goes directly to the matters that the jury alone is there to decide. In what Detective Belknap has prepared as an aid to assist the jury in understanding or hearing his testimony, he is explaining the methodology that he employs in making the categorizations and classifications of certain groups as a criminal street gang or not. Your Honor, without knowing how it is that Detective Belknap goes about making determinations and deciding whether he, in his opinion, believes that this particular group is a criminal street gang, how on earth is a jury to gauge his credibility? The court, of course, instructs the jury that the law comes from the court alone, and the court can give to the jury prior to Detective Belknap
I want to support
a
these black
limiting
women right now. I
instruction
swear I do.
saying that
They're
what
the
they
ops
are
right
hearing
now, man.
is his opinion
trying to
and
lock
the
black niggas
basis
up, man.
that forms his opinions. The law upon which Detective Belknap relies in order to make his classifications of particular groups is no different than treatises or other matters that experts rely on to make their particular opinions about matters that are outside the ken of the average juror. In this particular case, Detective Belknap does not place at the top of his slide OCGA blah, 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 and he does not say in order to find this person guilty of participation in criminal street gang activity, you do or don't need to have this. What he has done is outlined the factors that he employs in making a determination as to whether, in his opinion, a particular group qualifies as a criminal street gang. The circumstances of our case are quite distinguishable from those in Swanson. If it ever came to a point where, and we would not, where the prosecutor asked Detective Belknap something that was in the jury's, within their purview, do we need to have this to convict of this? Then I would see and understand defense counsel's objection. But here, without the jury knowing how it is that Detective Belknap made his decisions about whether or not this particular group qualifies as a gang, this particular group does not, how on earth are they to gauge whether or not he is credible? The court will tell the jury that the jury has to decide whether or not they believe Detective Belknap. What if Detective Belknap had a series of qualifications for determining whether or not a group is a gang that was completely out of line with Georgia law. Giving what he uses as a guide to make his determinations in no way invades the province of the jury. I'm certain that if he did have a series of qualifications or standards that were out of line with what the law is, no one can argue that the defense counsel wouldn't pounce on it and in fact exploit that fact for the jury. But the fact that his standards, his methodology, his qualifications, his determination of whether or not a group is a criminal street gang, because it is exactly as the law requires it to be, they want it excluded. And that in turn completely cuts the legs out from under the jury's ability to discern whether or not Detective Belknap is credible. How on earth could you expect them to gauge his basis for his knowledge at all without that information?
Okay.
So we would ask that the court find that there is no merit to the objection currently being made as it relates to the demonstrative aid that Detective Belknap seeks to employ, and that in no way
Judge, you
does
fucked up.
the utilization
They ain't ready to go
of
yet.
the demonstrative on page 1 of his demonstrative aid invade the province of the jury. Again, this is Detective Belknap deciding and determining and using a particular structural tool in making assessments of whether or not a particular criminal act is in furtherance of the gang. The triangle that is shown is in no way invasive or invading the province of the jury. It simply helps.
You said you just emailed. Yes, ma'am. I'm sorry.
No, thank you, Judge. It simply helps to explain how it is that Detective Belknap goes about making the determinations and forming the opinions that he has been qualified to share with the jury.
Sure.
And to suggest that this information is inadmissible, it just, I don't know, it just defies reason at this time, Your Honor. I would suggest that all of this information goes to the weight of Detective Belknap's testimony and in no way should be considered a reason to exclude the tools he uses to form his opinions. And thank you for allowing me to speak.
All right. Anybody else wish to add anything before I go ahead and rule? Mr. Sharp, you got up.
Separate issues with the same PowerPoint, so.
Hey, what's your issue, sir?
Your Honor, if you go to, there's a few slides labeled no slime light. It's, I'd say halfway through.
Okay, can you give me a slide? Is it the one that starts on October the 14th? Ms. Hilton and Ms.
Page 22, if you count them, Your Honor.
Okay, hold on, just wait. Ms. Love, is it possible for you to ask Detective Belknap tomorrow, before he testifies tomorrow, to label or to number his slides so it would be easy for me to deal with these kind of queries?
Absolutely.
All right, that would be wonderful. So, can you give me what page it's near, Mr. Sharp?
Where you just were, it starts on the one before this.
Okay, all right.
It says double-
YSL criminal activity?
Yes,
Okay, all right.
and it continues for, I think, 3 slides, including the one that you were just looking at. And it lists specific allegations that are not in this indictment, not charges
I'm about to
over
swear
acts,
now.
that are
We'll be back tomorrow when we get
criminal
back
in
to figure
nature,
this out. Like I'm
prejudicial,
we gone.
that discusses